Clause 38 on page 54 introduces section 195 to establish the general court-martial.
Away from the wide range of the intentions to establish the court-martial, a school of thought believed that the interest is to trap the opposition, especially civilians.
Section 117D on page 46 prescribes specific offenses that bring a person who aids and abets under the jurisdiction of the court-martial, and also introduces the element of conspiration. As the scrutiny of the UPDF Amendment Bill 2025 starts, questions surrounding the worries of the section of the public dominated the engagement of the Joint Parliamentary Committee on Parliamentary Affairs and the Defense and Internal Affairs, chaired by Stephen Baka Mugabe.
I would like to speak with my head, but also with my heart. In conversations like this, sometimes we use our hearts, become emotional, and we forget the common sense.
What would differentiate the attires of the military would be the symbols, the emblems that differentiate. There is no way you can tell me that a boot, a black boot, or any other clothing that does not have a symbol should be attached and gazetted to be a uniform of the military.
Attorney General Kiryowa Kiwanuka reminded the MPs of the recent Supreme Court ruling, especially on the matter of civilians.
Further, 6 justices noted that for a civilian to be tried in the court-martial, there needs to be in place clear exceptional circumstances.
And what are the exceptional circumstances pinning civilians?
Where a person is found in unlawful possession of arms, ammunition, equipment ordinarily being the monopoly of the defense forces prescribed in Schedule 7A of the Act, and classified stores in Schedule B of the Act.
But what differentiates the exceptional circumstances from the question which the Supreme Court answered?
Which I will also attempt to answer. The question was, is it lawful? Is it legal? Is it constitutional to try a civilian in the military justice system or military court?
So, but that's a conversation that what I need to state as a matter of law, the decision on the jurisdiction to be granted to any tribunal or court vests with the Parliament.
The loggerhead furthered as the Attorney General's response was found unsatisfactory.
I have not seen these amendments speak to the fact that the civilian courts are inadequate in trying these matters, and therefore the warranty being taken to the court-martial. These amendments are not stripping over that fact and are not introducing anything new to warranty exceptional circumstances.
But now you're saying they should. Why don't we look at strongly empowering these courts? Because, Mr. Chair, the bill is extremely beautiful. And if this bill was speaking to a young girl, the girl would only accept to go for marriage. But there is that hiccup that we need this legal mind. How do you justify? But we still have these courts. Are we now disempowering the civilian courts?
The UPDF Amendment Bill 2025 seeks to establish court-martial units, divisional court-martial, and the general court-martial accordingly. The bill also seeks to transfer some powers under the CDF to the Deputy CDF, including inspecting the forces. Daniel Mugoya, Gloria Gutabinji, UBC News.